Asylum Seeker, Refugee and Migrant Coalition is taking the Legal Practice Council to court. The coalition says the council is discriminating against foreigners for candidate attorney positions in favour of South Africans. For an in-depth chat on this, I'm now joined by Mchengeti Wacha, who is an attorney at the ASRM Coalition. Mchengeti, thanks for your time this afternoon. Could you explain the basis of the Asylum Seeker, Refugee and Migrant Coalition's legal challenge against the Legal Practice Council?
Thanks for the time, Hugo. Maybe just to begin, it's not focusing on all non-citizens living in the country. There are a particular subset of non-citizens in the country we call permanent residents. Now, our law has time and time again permitted permanent residents to compete for employment on equal footing with South African citizens. And so in circumstances where they are barred from exercising that right to compete on equal footing with citizens, that gives rise to concern. And that's what happened in this case. That's what Webber Wentzel was implementing as the policy that the ASRM Coalition laid a complaint against them at the Legal Practice Council.
I suppose it's also important to talk about statistics. Just how many individuals are affected by this policy, in particular when you talk about Webber Wentzel?
So the number of permanent residents in this country is not a large number of individuals. As you would know, it's a difficult process to go through the immigration requirements to get to a stage where you acquire permanent residence. Permanent residence, in terms of the Immigration Act, is a high status. Permanent residents are afforded all the rights that are accorded to citizens, barring just a few, such as voting and service in some high levels of government office. So for all intents and purposes, people who've been admitted into the country for permanent residence likely go on to become citizens after 5 or so years. So these are people who are in our country, who we've vetted thoroughly, who contribute to the economy. And that's why the law affords them such a high level of rights to compete with South Africans for employment.
Mchengeti, the LPC justified the exclusionary hiring policy as positive discrimination to meet BBE obligations. Why does the coalition view this as discriminatory against non-citizen permanent residents?
So the Constitution has envisaged a procedure or a manner in which companies or the state itself can advance historically disadvantaged people. That's what we call positive discrimination. However, there is always a tendency to overcorrect, and that is what must be guarded against. We mustn't go so far as to try and correct the inequalities of the past by perpetuating discrimination again to other groups. So that is the issue that the court has been faced with on multiple occasions. And the court has determined that in order to find a balance between advancing historically disadvantaged South Africans and ensuring that we do not overcorrect or perpetuate a new form of discrimination, the court has found a balance. And unfortunately, the policy that Webber Wentzel implemented fell foul of that balance that the courts have determined. And maybe just to elaborate on that a little bit, what the courts have said is that you cannot have what they call absolute barriers. So, for example, if a white candidate would like to apply, it is improper to say that no white candidates are allowed to apply for employment. What is required instead is for a company to say that we give preference to historically disadvantaged South Africans, but if none are found in the talent pool, we are then able to consider a white candidate. So those are the parameters of affirmative action. And unfortunately, Webber Wentzel's policy fell foul of that by creating an absolute barrier to the consideration for employment of permanent residents.
And the broader societal implications of the court rules in favour of the coalition?
So the main concern that the coalition has is that the LPC has justified the conduct of Webber Wentzel. And once it is justified in this manner, it means that the rest of the industry is open to adopt similar discriminatory policies. So that is our real concern, that if a firm of the caliber of Webber Wentzel is allowed to implement a policy of this nature, such a practice may permeate into the rest of the industry, which is detrimental ultimately to the rights of permanent residents living in this country.
Okay, Mchingati Wacha, attorney at the ASRM Coalition. Appreciate your time. Thanks for speaking to us.